Compulsory labor permeates our legal and judicial structure. Thus, much venerated judicial procedure rests upon coerced testimony. Since it is axiomatic to libertarianism that all coercion, in this case all coerced labor, against everyone except convicted criminals be eliminated, this means that compulsory testimony must be abolished as well. In recent years, it is true the courts have been alive to the Fifth Amendment protection that no alleged criminal be forced to testify against himself, to provide the material for his own conviction. The legislatures have been significantly weakening this protection by passing immunity laws, offering immunity from prosecution if someone will testify against his fellows, and, furthermore, compelling the witness to accept the offer and testify against his associates. But compelling testimony from anyone for any reason is forced labor, and furthermore is akin to kidnapping, since the person is forced to appear at the hearing or trial and is then forced to perform the labor of giving testimony. The problem is not only the recent immunity laws. The problem is to eliminate all coerced testimony, including the universal subpoenaing of witnesses to a crime, and then forcing them to testify. In the case of witnesses, there is no question whatever of their being guilty of a crime, so the use of compulsion against them, a use that no one has questioned until now, has even less justification than compelling testimony from accused criminals. In fact, the entire power to subpoena should be abolished, because the subpoena power compels attendance at a trial. Even the accused criminal or tortfeasor should not be forced to attend his own trial, since he has not yet been convicted. If he is indeed, according to the excellent and libertarian principle of Anglo-Saxon law, innocent until proved guilty, then the courts have no right to compel the defendant to attend his trial. For remember, the only exemption to the 13th Amendment's prohibition of involuntary servitude is except as a punishment for crime whereof the party shall have been duly convicted. An accused party has not yet been convicted. The most the court should be able to do, then, is to notify the defendant that he is going to be tried, and invite him or his lawyer to attend. Otherwise, if they choose not to, the trial will proceed in absentia. Then, of course, the defendant will not enjoy the best presentation of his case. There is little difference in kind, though obviously a great difference in degree, between compulsory jury duty and conscription. Both are enslavement. Both compel the individual to perform tasks on the state's behalf and at the state's bidding. And both are a function of pay at slave wages. Just as the shortage of voluntary enlistees in the Army is a function of a pay scale far below the market wage, so the abysmally low pay for jury service ensures that even if jury enlistments were possible, not many would be forthcoming. Furthermore, not only are jurors coerced into attending and serving on juries, but sometimes they are locked behind closed doors for many weeks and prohibited from reading newspapers. What is this but prison and involuntary servitude for non-criminals? It will be objected that jury service is a highly important civic function and ensures a fair trial, which a defendant may not obtain from the judge, especially since the judge is part of the state system and therefore liable to be partial to the prosecutor's case. Very true. But precisely because the service is so vital, it is particularly important that it be performed by people who do it gladly and voluntarily. Have we forgotten that free labor is happier and more efficient than slave labor? The abolition of jury slavery should be a vital plank in any libertarian platform. The judges are not conscripted, neither are the opposing lawyers, and neither should the jurors. It is perhaps not a coincidence that throughout the United States, lawyers are everywhere exempt from jury service. Since it is almost always lawyers who write the laws, Can we detect class legislation and class privilege at work?